And then I did also file a motion for bond.
And I understand. Sorry, I'm not trying to.
Nope, certainly, Your Honor.
I read it. We will go on the record in the matter 25 CF 125, 25 CF, that's it. State of Wisconsin versus Charles Kowski. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Kowski appearing in person in custody with counsel Joel Feliski. We're set today in this matter for a preliminary hearing and a request to modify bond from a cash bond to a signature bond, simply to allow Mr. Kowski to go serve his, I believe he was revoked on his extended supervision, and to go serve that time and start that clock ticking while we're moving forward with this matter. This will be a waiver, correct?
That is correct, Your Honor. I have a completed waiver form with me. May I approach?
You may. And before we begin on the waiver, Mr. Schmidt, any objection to the amending to a signature bond so Mr. Kowski can go to Dodge?
Yes.
You object?
Yes, I do.
Okay, all right. Well, then I'll hear arguments after. Okay, so Mr. Kowski, I have in front of me the waiver of right to a preliminary hearing. Do you understand this document and what it entails?
Yes, I went through it with my lawyer this morning.
Did he go over it very thoroughly?
Yes, he did.
Is that your signature on the first page?
Yes, it is.
And you understand everything that's stated on this document?
Yes,
Now, do you understand that once you give up your right to a preliminary hearing, it's forever and you can't get it back?
yes,
And do you understand that the state would have that burden to prove a felony was probably committed? And by agreeing to waive by waiving your preliminary hearing, you agree the state can at least meet that burden?
yes,
And so once you give up the right, it's forever. You understand that?
Yep.
Anyone make any threats or any promises to you for you to plead or for you to waive your right to a preliminary hearing?
no, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes,
and voluntarily?
yep,
All right. The court will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I find probable cause and I will bind the matter over. Information, Mr. Schmidt,
I filed the information. It mirrors the criminal complaint.
proceed with an arraignment or set for another date.
I'm comfortable with proceeding. I trust that the information mirroring the complaint, that Mr. Kowski understands the charges and the maximum penalties, will waive formal reading, and to each count plead not guilty.
Guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Has an offer been presented?
There has been an offer made in this case, Your Honor, and I guess to show my hand somewhat in terms of the motion argument, I believe there is interest in this offer. There may be some further negotiating on the specific terms, but the offer, I apologize, one moment, is for Mr. Kowski to plead to count one in the complaint with the modifier, dismissing and reading in the remaining counts in the complaint. Parties to request a PSI, state would be capped at the PSI's recommendation along with court costs and a stipulation as to any restitution.
Okay, Mr. Schmidt, argument as to, well, do you want to say anything more about your motion? Simply, I said it's pretty straightforward.
Only to make the observation, Your Honor, that Mr. Kowski will be remaining in custody this entire time. He's not trying to leave custody. And as I had already just mentioned, it does seem that this matter is trending towards resolution.
And he's been revoked off of ES. Do you have a specific amount of time? Did they say 2 years, 9
they're
months?
suggesting 2 years, 2 months, 2 days.
Wow, 222. 2 years, 2 months, 2 days. All right. Okay, Mr. Schmidt, argument?
So I'll say first and foremost, if he was going to prison for that amount of time, I would not oppose the request. According to Barron, their office, he waived the revocation hearing, but he's contesting the reconfinement period. That is, he's still going to have a hearing to argue where he shouldn't go back that long, and he could go back much shorter. The last time he was revoked on this ES, he went back for only 4 months, and that was for the 2022 felony theft case here in this county.
That's incorrect. I had to do 1 year, 1 month, 1 day. And the only reason I went back for 4 months or 5 months was because I had already served prior to that. So I figured I would at least be going for at least 1 year, 1 day.
Mr. Kowski, you can make a statement after.
Sorry.
I have to hear Mr. Schmidt.
I'm sorry.
So as he said, he went back for 4 months, according to DOC records, which I checked. As for his history, he has 13 prior convictions. 1 conviction is for burglary, 1 conviction is for burglary with a firearm in his possession. He's had 2 burglaries read in. He's had 2 burglary tools read in. He has numerous convictions for felony bail jump and those being read in. This case alleges Charles Kowski of committing a burglary while on extended supervision for a burglary and while on bond out of Barron County for methamphetamine. The evidence in this case is we had a GPS on his vehicle and saw him go to an area that seemed suspicious. We went there and called the owner of the land, confirmed it was burglarized. We then went to his property and found the stolen property in his possession. We checked cameras from between the property and Rice Lake and saw Mr. Kowski's truck with the stolen property in it. Yes, he's been revoked off of the supervision, but I'm concerned with how much he might go back given how short a time he went back last time. He does have a history of non-appearance. I have found 4 missed court appearances. Most of his cases, it hasn't been possible for him to miss court because he's either been in hold status through DOC or through being on high cash bonds. He has good reason to run because of the high potential penalties with the repeaters on these charges and with the certainty of conviction given the strength of evidence. He was caught red-handed with stolen items after his vehicle was tracked from the scene with GPS and caught on camera the same. This is a statutory violent crime he committed while in extended supervision for a violent crime, meaning that's something the court has to consider with the new bail statute. He was originally sent to prison for 5 in, 5 out in 2008. That's a 2008 case he's on extended supervision for. He's gone much longer than 10 years total because of the holds and the revocation previously. I think the court has to consider all of that. I do think he's a risk to the community. I think there's a risk his time in Dodge may be extremely short, and I don't think that our community can suffer risking that. He has too consistent of a history of the bail jumps, committing new crimes on bond, of doing burglaries, which is a violent crime that victimizes the community. And in this case, he was on supervision for that, and he was on bond out of Barron, and that didn't do it. We're gambling too much by doing a SIG bond now just to stop the counting and hope that some bureaucrat down in Madison is going to do a long period of time incarceration.
This is the legal turning point of the hearing. The prosecutor lays out why the state believes Charles Kowski should remain on a cash bond, emphasizing his prior convictions, history of burglaries, alleged new offenses while on extended supervision, and concerns about community safety. From a legal standpoint, bond decisions are not intended to punish someone before trial. Instead, the court evaluates factors such as public safety, the likelihood of appearing for future court dates, and the seriousness of the alleged offenses. The defense responds that Kowski isn't asking to be released into the community, only to begin serving his revocation while this case continues. So here's the question. Should the court focus primarily on efficiency, or should public safety concerns outweigh every other consideration? Let's return to the courtroom as Judge Melissa R. Mogen explains how she reaches her decision.
Sentence.
Thank you. And I understand, Mr. Kowski, what you stated when Mr. Schmidt was arguing. I remember that. I remember you had that time served, that credit, and that's why you only sent that 4 months. I'm denying the request to modify, and for this reason, and this is why. Not based upon the arguments that the state has made, but more so based upon the arguments that the defendant has made. If this matter is proceeding as it is likely to reach a resolution, that's telling the court it's likely to reach a resolution rather quickly, other than stalling and delay and keeping the matter from reaching fruition or reaching an end point. This is a serious crime. The court would require at most a sentencing in person. The plea may be done by video conferencing if you're okay with that, but at most the sentencing would need to be in person because it is a serious felony. That would mean that there would be cost put upon Burnett County to have to go and retrieve you from Dodge and then to bring you back just for sentencing and then to potentially bring you back to Dodge. So that is 4 trips, 2 round trips that the court would have to order be done, and that would put additional costs upon the county when resources are scarce as it is. And so that is why the court is denying the motion to modify the bond, because this is a serious crime and with the need to have the in-person. I don't know if you're going to have lesser time than 2 years, 2 months, and 2 days. Honestly, I don't care if you're going to have lesser time. If they're even sending you back for 4 months, that would be the ALJ or the state's, not the ALJ, but the state's determination of that length of time. But
Judge Melissa R. Mogen ultimately denies the request to modify Charles Kowski's bond, but her reasoning focuses on courtroom logistics and the efficient handling of a serious felony case rather than adopting every argument presented by the prosecution. She explains that because the case appears to be moving toward a possible resolution, changing the bond now could create unnecessary transportation costs and delays by requiring multiple transfers between the county and state correctional facilities before sentencing. The hearing highlights how bond decisions often involve practical court administration alongside legal and public safety considerations. With the motion denied, the case moves forward on an expedited schedule while the parties continue discussing a possible resolution. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
I don't think we can afford to gamble it. I'd ask the court not to. Thank you.
But realistically, couldn't the court be creative and craft a bond that would mean that if he is released from his extended supervision revocation period, he can be brought right back to Burnett County?
I don't know how you could craft it in a way that wouldn't require him to comply with it and voluntarily come back with it.
All right, any rebuttal?
Your Honor, beyond the statement made by Mr. Kowski, again, I think that the point here that he could potentially sit less time than what is recommended by the department is speculative. We don't know how the department, or as the state put it, a bureaucrat down in Madison, is actually going to rule on this matter. Your Honor, we're not asking for Mr. Kowski to be let out. We are simply asking for him to be transported and allow him to begin serving that